JC and I would argue against many European ideas, yet a global struggle requires a global strategy, and these conceptions cannot be ignored. Thank you once again for this very special invitation. I look forward to participating in the panel. My most sincere thanks again to the Justice Department for convening this important program.
I want to thank the Attorney General and the Justice Department for putting together this day-long conference on anti-Semitism. And in my comments, I'm going to speak to what has been one of the largest and I think most successful policy initiatives, legal initiatives, to combat on certain manifestations of anti-Semitism. Manifestations that are not like the ones we just saw in the memory video, truly scary calls for death, but rather manifestations that are in some ways more difficult to deal with because they come cloaked in the mantle of human rights discussions. So in the past 4 years, 27 American states have adopted so-called anti-BDS laws. Now, what these laws say is that the laws do not ban boycotts of Israel. They do not prohibit anyone from boycotting Israel. What they do say is that boycotts of Israel are a form of bigotry and discrimination. The 27 states have classified such action discriminatory, bigoted, and thus the state will not do certain kinds of business with companies that choose to boycott companies or people simply because of their affiliation with Israel, simply because they have a connection with the State of Israel. Now, this has been an extraordinary wave of legislation, I would say almost a groundswell. There's been a deep, and it shows a deep recognition by American policymakers of this close connection between bigotry, anti-Semitism, and boycotts of companies and individuals based not on what they personally have done, but based on their affiliation, connection, presence in Israel. Starting with South Carolina and Illinois in 2015, this has really swept the nation in an extraordinary wave. One thing that needs to be pointed out about these laws, at a moment when so many things, including matters related to Israel, but also pretty much everything else, are seen as polarizing, divisive, drive Republicans and Democrats apart. That's not just Israel, that's everything here in this city. These anti-boycott laws have been extraordinarily bipartisan and produced an extraordinary policy consensus. In all 27 states that have enacted this, the measures have been overwhelmingly bipartisan, and indeed they've passed by overwhelming majorities and sometimes often near unanimity. So Republicans and Democrats in state houses across the country, in red states and blue states and purple states, have lined up and said, refusing to do business with someone, a discriminatory refusal to deal with a company, with a person, with an entity because of their connection to Israel, that is something that is discriminatory enough that we will not prohibit it necessarily, but we do not want our state taxpayer money going to subsidize that kind of activity. And so these laws, just to give you a few more details, they come in two forms. Some say that states will not do business with companies. They will not contract with companies that engage in this kind of discriminatory refusal to deal. Others provide that the state won't invest their pension funds in such companies, and some do both. The understanding here, and I think one of the most important things about these laws, other than their actual effect, is the message they send. Because too often, those who wish to discriminate on the basis of Israeli origin, on the basis of Israeli nationality, try to take for themselves the language of human rights. They say, we're not discriminating, we're boycotting, which is supposed to make some kind of difference. We're doing this because we don't like, because they're doing bad things. They're doing bad things. We disagree with their conduct. Now, recently, Germany, Canada, and courts in France and Spain have concluded that treating Israelis people present in Israel, companies present in Israel, as a fixed class and refusing to do business with them, what's called boycott, is indeed anti-Semitic, is indeed a form of discrimination. We've had very recently strong expressions by the German and Canadian parliaments of this, and now 27 American states are saying the same thing. They're saying the same thing. What's crucial to stress is these laws do not in any way penalize companies for their views about Israel. It is not the views about Israel that these laws target, but economic conduct aimed at Israel. Let me give you a couple examples. If a company hangs a banner from its headquarters, "Down with Israeli apartheid," hangs a big Palestinian flag, they're entirely eligible for state contracts and state investments under all 27 of these laws. On the other hand, if a company, not because it has any opposition to Israel, but because it's bullied and intimidated by boycott activists, chooses to refuse to deal with Israel, even if they're singing Hatikva while they do it, they will indeed be subject to these laws. That is, for example, the case of Airbnb, which made it completely clear that its partial boycott of Israel was not based on opposition to Israeli policies, had no ideological basis whatsoever, but was based on years of bullying and intimidation by boycott activists. Indeed, one of the insights of these laws is that companies that boycott Israel typically do not do so out of ideological conviction. They do so because they've been exposed to various pressures. And this is an insight which I personally owe to Ian Anderson, who is the principal flautist and lead singer of the rock band Jethro Tull. He plays often in Israel. And in an interview, he decried musicians who cancel their concerts because of boycott pressure. He said many bad words about them that we will not repeat in the Great Hall, but he also said that they are not rock and rollers. Why? Because how were they targeted? The boycott activists, they don't start with the phone book of rock musicians with ABBA and work up their way up to ZZ Top. They see who is already doing things in Israel, who's already playing concerts, and they target them. So the people who succumb to boycotts are those who have already performed, who have already done business in Israel, who are planning to do more. They don't have a problem with Israel, but the social costs are made so high that they give up on it. And so that's not rock and roll. The same with companies like Airbnb. Airbnb was targeted because it didn't have a problem doing business in Israel and in the West Bank. That's why they were doing it. And the goal of these campaigns is to make the costs greater than the benefits. But what this shows is decisions to boycott Israel are not necessarily ideological decisions. And that's a point that's going to be relevant in a second when we talk about the First Amendment concerns. Israel is the home to the plurality of the world's Jews. It is also the only country in the world with a Jewish majority. Actions taken against on the basis purely of Israeli affiliation or identity are a clear proxy for anti-Semitic actions. It's true also that there are Jews living elsewhere, but we do not find it to be a defense to discriminatory conduct to say, yes, I'm only discriminating against a minority group in this one place. In the rest of my business, I don't discriminate against them. Partial discrimination is indeed also discrimination. Now I want to say something about how these laws are modeled. These laws are not the only laws that say if you discriminate against a certain group, if you refuse to do business with people because of their membership in a group, because of some characteristic, the state will not do business with you. At around the same time these laws were being passed, 20-some states also passed, and the federal government, through an executive order promulgated by President Obama, passed measures saying that companies are free to not hire, to discriminate, to boycott people on the basis of their sexual orientation. But if you do so, you're not going to be doing business with the federal government. You're not eligible for federal government contracts. And indeed, state laws provide for similar restrictions for a wide variety of statuses: veteran status, marital status, and many other statuses. But most saliently today, there's dozens of state laws and executive orders that are structured exactly like the anti-boycott ones, like the anti-BDS laws. You cannot do business with these people, But we consider that bigoted, and as President Obama said, we don't want to subsidize this bigotry with federal taxpayer dollars. And here we get into what I find perhaps the most frightening level of anti-Semitism in this discussion. Some of the very same organizations that lobbied federal and state governments to adopt rules barring state contracting with groups that boycott gays are now the exact same groups, the ACLU in particular, that have bringing lawsuits challenging the constitutionality of the state anti-boycott laws. And the state anti-boycott laws now are the subject of significant litigation in at least five states. Two federal district courts have found that they unconstitutionally restrict speech. One has concluded the opposite. There is no speech issue here. Deciding who you do and do not do business with is not a form of speech. There is no speech being regulated. Indeed, if refusals to deal were a form of speech, all anti-discrimination law would be called into question. In attacking these laws, the ACLU says, oh, this is different. Here, it's a politically motivated refusal to deal. People are boycotting Israeli companies for a reason. And there's two things to say about that. First of all, it's not true, and secondly, it's not a distinction. As we said, most of the companies pressured to boycott Israel, those who these laws certainly contemplate, have no explicit or implicit political agenda whatsoever, and they say so. So it's not true that boycotting Israel is inherently political. It could be done to win favor in the Arab world, as the CEO of Orange Telecom, the big French telephone company, said at a hot mic at the Cairo Chamber of Commerce, we're boycotting Israel, can you please give us some business now? Or because of pressure from NGOs, as in the case of Airbnb. But more importantly, it's not a distinction, because we know it is not a defense to being made ineligible for federal or state contracts because one boycotts people on the basis of sexual orientation to say, oh, I have an ideological problem with that sexual orientation. I find what they do problematic. I find their political positions problematic. I think they have harmful effects. That doesn't help at all. That does not in any way preclude the application of those state laws. Indeed, all of these boycotts are sometimes ideological and sometimes not. The Supreme Court has clearly held in Rumsfeld versus Fair that simply choosing not to do business with people is not speech. Why? Because there are many reasons you could not do business with them, including you're just not interested in their business, and many other factors. If you need to have a special explanation of why you're not doing business, as we see in many of these cases that the ACLU has brought. In one of these cases, for example, the plaintiff is not buying a Hewlett-Packard printer. Even a very informed observer would not know that that decision could conceivably have anything to do with Israel. But he says they have some business with Israel, so he's not buying a Hewlett-Packard printer. The action tells you nothing, the non-purchase of a Hewlett-Packard printer. It is only the explanation, because Hewlett-Packard printer does business with Israel and I have political disagreements with Israel. That's the protected speech. The explanation is protected, the action is not. And the ACLU lawsuits against these measures threaten to undermine all of anti-discrimination law, all of foreign sanctions law. Because of course, if choosing to not do business with a country or companies based in the country is a natural way of expressing opinion about that country, isn't doing business with companies based in the country also a natural way of expressing approval of that country? So all someone would have to do now is say, I'm not doing business with Iran because I want to make money in the oil sector. I support the Iranian Revolution. Such an idea has never been suggested. It goes against everything we know. And I think what's most dangerous now is that the anti-BDS laws have provided valuable protection and a valuable message that boycotting based on Israel connection is anti-Semitic, is discriminatory. But now there is a conscious effort by major organizations to actually do something even scarier, to create a second-class tier of discrimination. That all discrimination can be protected from by the denial of state contracts, except when it's discrimination based on connections to the Jewish state. There's a First Amendment right to do so. And that would create the most dangerous double standard to Jews of all. Thank you.
This has been a great discussion. So we have a few more minutes to sort of get into the discussion, and I want to pick up on what you just said, and I want to ask you, Chris, first. Do you believe that boycotting a state is First Amendment protected political speech?
Well, I'm hesitant to weigh in on that. It's a bit outside my lane, but I think it could raise difficult issues. You could see some context in where a decision to take some kind of action would be a reflection of belief for the government to then prohibit you from engaging in a particular conduct where it's a reflective of a belief. There could be an issue, but on the other hand, states, the federal government generally has very broad contracting authority. There's a line of cases that affirm that, and so there are, Eugene makes a strong case for his position, but I do think it raises some significant and interesting issues, and I would need to look at it a lot more carefully before offering much more than that.
Okay, and I want to ask you now, Eugene, to respond to something from an ACLU, former ACLU attorney named Amanda Shanor, who wrote this on Jack Balkin's blog. And I just want you to respond to this one point. Ordinary public accommodations laws regulate routine economic behavior, the buying and selling of goods and services, which does not generally trigger First Amendment coverages. Anti-BDS statutes, by contrast, specifically aim to silence a key form of expression, political boycotts, because of its message. Their aim is to quell dissent. Now, I know you've addressed the sort of broader point, but I want to nail down on this idea that isn't there a difference between boycotting an individual, an American citizen, for their sexual preference, their gender, their race, their religion, and boycotting a country, which happens all the time? I mean, certainly, I'm sure we wouldn't, I think there ought to be more boycotts of Iran or China. You can go through the list.
So first of all, there's a question whether there should or shouldn't be, and then there's another question, could the government regulate it if it disagrees?
So is boycott...
So I want to say something very important about these laws. These laws are not about boycotts of the state of Israel. These are boycotts of, as the laws themselves say, persons or companies doing business in the state of Israel and territories under its control. So it's boycotts, yes, of persons because of their characteristics. Under these laws, people are not going to be disbarred from state contracts because they don't want to enter into a defense contract with the state of Israel. That's understood. So it's not the state of Israel that's on the protected end of these laws. It is, for example, take the Airbnb example, because this was one of the more open and publicly discussed issues. Who was on the other end of the Airbnb boycott? People who own small rental units. Some 200 owners of